20 new tax laws. The IRS, always willing to say we can do it, it will be difficult, but we can do it, is going to be asked to invade Americans' lives like never before. Who you're sleeping with, who's in your bedroom, who you're married to or not married to, will in fact affect your status and perhaps cause your taxes to be taken retroactively because of a change in income, marital status, persons living within the home during the year. President Obama said you could keep the health care you wanted, but of course that's not happening. It's not happening in such great numbers that states who decided to rely on subsidized, under the Obama health care plan, subsidized health care, are being told that involuntarily the Federal Government is setting up exchanges that will in fact preempt states' rights, preempt federalism once again. Under the letter and the discussion on the House floor of Obamacare, it was very clear that states could choose whether or not to set up exchanges, and if they did not, Federal exchanges would not be subsidized. It was considered to be an incentive that only 4 states have chosen. Americans know today that, in fact, this was one of the largest and most complex tax increases in American history. We know that whether you're a medical device manufacturer finding that you're being taxed so as to raise the cost of health care in order to pay for health care, or whether your dividends and interest are being taxed for the first time ever under Medicare, or whether or not getting married could cost you $3,400. The fact is, under Obamacare, if you are $25,000, in other words, $10 an hour with a little bit of overtime, but living unmarried, you will receive about $1,700 in subsidy. If you live with somebody who also makes $25,000 and is unmarried, they will get about $1,700. But if the two of you are foolish enough to get married, you will lose that $3,400. The numbers are not debatable. What is debatable is, with rules not yet written on a law that was so vague that time and time again the administration tells their political appointees to interpret the meaning, to find that which is not within the 4 squares of the law and simply say it was congressional intent. I am one who was here for that vote. The intent was clear. It was an intent to deceive. Obamacare was in fact a series of promises by Nancy Pelosi to Democrats in order to get them to vote for things that they otherwise wouldn't have. Those Democrats, some of them here, some of them no longer here, have in greater and greater numbers realized they were lied to. Whether it was interfering with churches, interfering with people's personal right to stay with their own insurance company, or in fact interfering with federalism itself and states' rights to choose or choose not to participate. Time and time again, this administration has broken promises through interpretation. It has been a long time since this committee has looked at an IRS commissioner and had to say what it will say today, which is, Madam Commissioner, you do not have the authority. You simply have the political will to interpret that states must, over their objections, operate effectively state exchanges, because if you don't do it, we will do it for you, and without coming back to the Congress for a change, you will cost the American people billions of dollars, hundreds of billions of dollars over 10 years that were not scored in the bill. Ultimately, Obamacare, and I'm calling it Obamacare from now on. I'm tired calling it an affordability bill. It's not. It's not about quality health care, and it's not about affordability. It was the largest increase in federal spending, and it scored in a way that was not true. Our primary reason today is to flesh out some of these clear problems, problems where either the law is unclear, or when the law is clear, it's chosen to be ignored, or more importantly, the intrusion by the IRS in our lives. Under this legislation and its interpretation by political appointees at the IRS, we will see every aspect of your American life audited by the IRS in an increasing way, so much so that I doubt they can in fact go after the conventional tax cheat for the next several years. In closing, I do not blame the IRS. They're just following political orders. I blame the President of the United States for pushing, when he can't get through legislation, implementation of things that were not within the four square. Treasury and all of its individuals need to recognize that we will hold them accountable for the mistakes and the intrusions into people's lives. Lastly, for the American people that may be aware of today's hearing, there are many things which people object to in the census, which comes once every 10 years with follow-ons throughout. The census will not be nearly as intrusive as the IRS will be under this. States will be receiving information, and other individuals, the IRS will be receiving information related to many things that have never been within the four squares of the Internal Revenue Service. More importantly, portals will be wide open to those who need to know about whether or not you're married, you have a change in employment, and the like. So the opportunity for leaks out of the IRS outside of Federal IRS employees will inherently grow. I'm extremely concerned that January 2014 will come and we will have one after another failures to maintain the confidentiality of this new and expanding information. Lastly, the American people need to understand insurance carriers and exchanges will receive credits based on what the IRS believes should be paid. You may not go to a doctor the entire time. You may, in fact, want no health care. You may be 30 and healthy. But if your income rises, you marry, or do anything else that might affect that standing, or if the IRS simply overpays, they will not go back to the insurance company who shouldn't have gotten the subsidy. They will go to you and take the money. You will be done by the IRS, an organization which can pursue you through bankruptcy, which has no limit to its powers to eventually collect back money that you may not have wanted to spend. And by the way, that $3,400 on the board and others, your employer will also be first being told that he participates under Obamacare in that subsidy if he doesn't offer health care and you chose an exchange. But, oh, by the way, it is doubtful whether or not he will get it back as they choose to collect it from somebody who ultimately made more pay than what was possible for the subsidy. That and so many other questions, so many other dozens of questions are with us today. I want to thank our panel and recognize the ranking member for his opening statement.
Good morning. It is, I have said it to my constituents and I have said it to my family. The 30 years that I've been in public life, there is nothing that I have done, no vote that I have cast, that I'm more proud of than the Affordable Care Act. And the reason why I say that is because I see the people who will help, and I know that there are people who will die without it. That's real. And as I said to some constituents the other day, if they want me to leave my neighbors on the side of the road, sick, unable to get preventive care, in order, like the lady that I met the other day with colon cancer who said, "Congressman, just save my life. I have no insurance." Unfortunately, we were able to work with her to get her an NIH. Then those are the people who will benefit. And I will say that as we address this IRS issue, this is the United States of America. We can do this. We can get this done. The Affordable Care Act is a landmark achievement that will save huge sums of money for our nation while extending health insurance coverage to millions of people. They are the ones that get up early. They get the early bus. They work hard. They give it everything they've got. They're our mothers, our fathers, our friends. They're like Tyrone, the gentleman who lived down the street from me, who died, and the last word he said to his wife on his sick bed was, Marie, I got to get up out of here. I ain't got no insurance. Talking about them, our fellow Americans, the ones who send us here. So last month, the Congressional Budget Office issued a report finding that the Affordable Care Act will extend health insurance coverage to 30 million people who do not have it today. They're not collateral damage. They're our people. They're Americans. That is an amazing accomplishment that our nation should be proud of. In addition, our constituents are already seeing how the Affordable Care Act is putting money back in their pockets. This week, insurance companies are returning to their customers, our constituents, more than $1 billion in the form of rebates and lower premiums. That is a direct result of the Affordable Care Act. Just yesterday, women in private health insurance plans became eligible for life-saving preventive health screenings with no copays. This is part of the Affordable Care Act's comprehensive effort to save money by focusing on prevention. These are the women in our lives, our nieces, our daughters. It also addresses the historic disparities women face when paying for health care. The Affordable Care Act also has begun to ensure that seniors, like my mother who is 86 years old, have access to preventive care. Young adults have access to insurance on their parents' plans. And individuals are no longer subject to lifetime limits on their care. While all of these reforms are being realized now, many significant changes are yet to come. The Internal Revenue Service is a key agency charged with implementing many of the Affordable Care Act's provisions by 2014, including minimum coverage requirements and tax credits for individuals purchasing health insurance on the exchanges. This is a considerable undertaking for the IRS, but we can do this. Experts from the Government Accountability Office, the Inspector General's Office, and the National Taxpayer Advocate have reviewed IRS's efforts to date, and they have concluded that the IRS is on the right track to successfully implementing the new law. For example, GAO issued a report that says, and I quote, the IRS generally followed leading practices for implementing such a large program, particularly at the level of individual offices and projects, emphasizing that top leadership has been involved, end of quote. In addition, the Inspector General issued a report that says this: appropriate plans have been developed to implement tax-related provisions of the ACA using well-established methods for implementing tax legislation. And in her testimony today, Nina Olson, the National Taxpayer Advocate, says this: since ACA enactment, the IRS has been working through the major challenges, making significant progress. The lead time provided by the ACA has been very helpful for the IRS, and at this point it appears the IRS has used the time well. Certainly there are significant challenges in implementing this law, and as IRS moves forward, it benefits greatly from the continued rigorous oversight and recommendations from GAO, the IG, and the National Taxpayer Advocate. At the same time, we recognize that the IRS has been actively planning to implement the Affordable Care Act for more than 2 years, and it has already implemented many of the provisions successfully. For the challenges that remain, the IRS is working closely with taxpayers, the business community, and the insurance industry to ensure that its policies are responsive to consumers and consistent with the intent of Congress in passing the law. And I remind us that this is the law. Today, the committee is faced with a choice. Do we act constructively or destructively? Do we build up or tear down? Do we help or do we hurt? On one hand, we could work with the IRS and its oversight entities to ensure that the Affordable Care Act is successfully implemented, particularly now that the Supreme Court has ruled that it is constitutional. On the other hand, we could try to exploit any and all ways to bring down this law or starve the IRS of the resources it needs to do its job. I personally hope that we pursue the first approach. However, Republicans have introduced legislation to do the second. The Congressional Budget Office has examined the Republican bill to repeal the Affordable Care Act and concluded that it would increase the Federal budget deficit by $109 billion over the next 10 years. It is time to accept the Affordable Care Act, to accept the Supreme Court decision, and to accept the billions of dollars in savings this law will bring to our citizens. I look forward to today's testimony, and I want to thank all of our witnesses for being here today. Mr. Chairman, I yield back.
I thank the gentleman. We now recognize Dr. Desjardins for an opening statement and a unanimous consent.
Thank you, Mr. Chairman. Chairman Issa and Ranking Member Cummings, I appreciate you holding today's hearing to further examine how the Internal Revenue Service has been implementing provisions of the Affordable Care Act. One of our chief responsibilities on this committee is to ensure that taxpayer dollars are being utilized both efficiently and in accordance with the law. Unfortunately, it has become undeniably evident that the Affordable Care Act falls short on both of these principles. Just last week, this committee held a hearing on a new Health and Human Services demonstration project that the Obama administration is paying for by cutting $8 billion from Medicare Advantage. These are funds that would normally be used for patient care. Two members from the nonpartisan Government Accountability Office stated that this demonstration project was unprecedented, flawed from its inception, and will ultimately demonstrate nothing. Further, there is strong evidence to suggest that the sole purpose of this project was nothing more than an attempt by this administration to hide new costs that Obamacare imposes on seniors until after the election. I fail to see how this is an efficient use of taxpayer dollars. There are the sort of examples that we've come to expect from this haphazardly passed bill, authored by individuals who told the American people that they would have to pass it in order to find out what was in it. Well, today I want to focus what is not in it. We have now discovered that when the Democrats were drafting Obamacare, they left out important language relating to federally run insurance exchanges. Democrats wrongly assumed that the states would rush to set up exchanges once the bill was signed into law, but a majority of them are still yet to do so. Section 1321 of the bill gives authority to the Federal Government to set up exchanges in states that fail to do so on their own. However, the law only gives State-run exchanges the ability to issue premium assistance or tax credits. Nowhere does the bill grant this authority to Federal-run exchanges. The Obama administration and proponents of this rule have stated that this was a simple drafting error. I don't see how they can possibly make this claim when Democrats had ample opportunity throughout the reconciliation process where they specifically extended tax credits to exchanges created by U.S. territories, yet left Federal exchanges alone. This leads me to believe that this was in fact a deliberate and premeditated action on the part of the Democrats as a way to incentivize states to set up the exchanges. Either way, there is no doubt that the language is missing. In order to fix this glaring problem, the Internal Revenue Service circumvented Congress's legislative authority by issuing a rule allowing premium assistance subsidies to be offered through Federal exchanges. Back in November of 2011, my colleague and fellow Tennessee physician Phil Rowe and I sent a letter to the IRS Commissioner asking what authority his agency had to unilaterally alter the Affordable Care Act and what specifically within the bill gave them the authority to bypass Congress in promulgating this rule. The response we received from the IRS cited no specific section or language justifying their actions. Mr. Chairman, I ask unanimous consent that this letter and the IRS's response be submitted into the record.
Without objection, so ordered.
On June 18th, I introduced H.J. Res. 112, which would nullify this rule under the Congressional Review Act. I firmly believe the actions by the IRS set a dangerous precedent that flies in the face of our constitutional separation of powers. I am pleased to announce that Senator Ron Johnson has recently introduced companion legislation in the Senate. Ultimately, my bill and this issue are not about the merits of the President's health care law, but on how the IRS has overstepped the authority it was given as the result of the Affordable Care Act. While my colleagues on the other side of the aisle may not share my views regarding the detrimental effects that Obamacare will have on our country, surely they will agree that the framers of our Constitution were clear in giving Congress sole legislative authority. Just because Democrats hastily drafted their health care law due to electoral politics, it doesn't mean they can now throw the separation of powers out the window. I look forward to the hearing and the testimony presented before us today, as well as having the opportunity to question our witnesses on these very important issues. I yield back the balance of my time.
I thank the gentleman. Members may have 7 days in with which to submit opening statements for the record. We'll now recognize our panel. We welcome our witnesses on the first panel. Mr. Mark Everson was Commissioner of the IRS from 2003 to 2007 and is currently Vice Chairman of the Alliant Group, and I might note also one of the architects of Governor Mitch Daniels' changes in Indiana. Ms. Nina Olson is currently the National Taxpayer Advocate at the IRS. Mr. Timothy Joist is Professor at Washington and Lee University School of Law, and Mr. Michael Cannon is Director of Health Policies at the Cato Institute. Ladies and gentlemen, pursuant to the rules of the committee, would you please rise to take the oath and raise your right hands. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth? Please be seated. Let the record indicate all witnesses answered in the affirmative. As is the tradition of my predecessor, I will note that you have a time and lights, so I would only ask that you deal with it just the way you would green light, drive through. Yellow light, drive through fast so you don't get caught on the red. Red light, please do a final summary as soon as you see your time has expired. And your entire opening statements will be placed in the record, so you need not go verbatim. It will all be there. Mr. Everson.
Sorry, it's been a while since I've done this.
You know, none of us can remember not to hit those buttons. They put a little light on ours to make it easier. Please.
Good morning, Mr. Chairman, Mr. Cummings, members of the committee. I'm pleased to be here. As you've indicated, I am the Vice Chairman of Alliant Group. I want to stress that my remarks are my own, not those of that business. But I would say that we work with CPA firms around the country, and some of the reflections I'm going to make are really tied to things that I've been told. I would also say that I'm not here to advocate for or against repeal of the Act or of any specific components of the Act. I'm trying to help you grapple with this issue of the IRS and its implementation. As the GAO has noted, this is a massive undertaking. That's the wording they've used. Very significant for the service. Nina Olson, my colleague, former colleague, and the National Taxpayer Advocate has said that with proper planning and funding, the IRS is fully capable of implementing health care reform. I'm not so sure. Now, clearly, I know that the service is going to do everything it can to implement it. They always do, but this is really quite a heavy lift, if you will. There are really 2 questions. One, can they do it? And even if they are able to do it, will there be collateral damage to tax administration as they're working on this set of issues? They're both important questions. The service grapples with 3 things when it's implementing laws. Are there adequate lead times? I think there are generally in this Act. Is there adequate funding? That's essential if they're to do their job. I counsel you to make sure you provide the funding that they need. And then finally, complexity. There's a lot of complexity and ambiguity in statutes, and that's certainly the case here. And as Nina has said, complexity is the most serious problem confronting taxpayers. And clearly, this is a step backward for tax administration because of what the IG has said is the introduction of the most complexity in over 20 years to the tax code. So that's a big problem. In my testimony, which you have, I've raised a number of issues. Let me just mention a few. The first is information technology. This is going to be a real challenge for the service. And as you've indicated, reliance on a lot of outside parties will be the case. You don't have to go any further than today's news reading about millions of trades on the stock exchange going forward because of rogue programs or bad programs to know that errors get made. Systems issues are tough, a lot of challenges for the service here because of the need to constantly update information. This is going to be a challenge. The second piece, you've already mentioned, Mr. Chairman, is the protection of taxpayer data. If there was anything I really worried about as Commissioner, that was it. And there is a risk here that there can be disgorged information, and it would be very damaging to the service and the confidence of taxpayers in the IRS if that were to happen. The other point that I would make is the burden on CPAs. CPAs struggle as it is to keep up with all of the changes in the tax code. They are the true advisors to small and mid-sized businesses. They don't have the staffs of a Merck or a GE to work through all this, and this is going to be very challenging. We get a lot of feedback on this at Alliant Group. Let me, before I close, I've got three very general points that I think are very important to place this in the overall context. Health care reform comes at a very difficult time for the IRS. In part, it's Congress's doing. We're heading towards the end of the year where there's a great deal of ambiguity about what the law is. I really do encourage you to resolve these issues because American businesses need certainty to make investment planning. But beyond that, I think the IRS is looking at the most difficult filing season next year, 2013, that it's had in decades because of the convergence of these factors and the potential for tax reform. So the competition for resources at the service and at management attention, they only have so many senior managers, of course. This all comes at a very difficult time. A second point I would make that I think is sort of overarching is the independence of the service. For important and well-understood reasons, the IRS operates with a great deal of independence from other agencies. I worry that such direct participation of the service in a major non-tax administration initiative has the potential to erode the historic independence of the service. And let me be clear here, I have nothing but the highest regard for Commissioner Shulman and his team. I'm not suggesting I've seen things, but I just think that when you bring the service in closer to the White House and to other agencies, you just run the risk of eroding that independence. Let me conclude by touching on the politics of this and how it does impact the service. I would say that with the Supreme Court decision and the clear transfer of looking at all this back into the political arms of government, it's also clear that the service is coming under attack. It would appear that some opponents of the Reform Act will demonize the IRS in order to build a case for overturning the law. The most striking example is the disturbing comparison of the IRS to the Gestapo by the incendiary governor of Maine, Paul LePage. Reuters quotes LePage as having said, quote, "What I am trying to say is the Holocaust was a horrific crime against humanity, and frankly, I would never want to see that repeated. Maybe the IRS is not quite as bad yet." Close quotes. Attacks upon the IRS of this kind are unconscionable and will ultimately take their toll on the service, its people, and the ability of the IRS to collect the money that we need to fund the government. I would close by saying that I would suggest that even if the service is successful in executing the long list of tasks assigned to the IRS under the Affordable Care Act, there's still an unquantifiable but real risk that health care reform will falter or perhaps, and nobody can be sure of this, but perhaps even fail because of the sheer number of moving parts and complexity of the new system. Let's hope health care reform is not a modern-day version of the Vasa, that famous top-heavy Swedish warship built in 1628, and when it sailed out of Stockholm Harbor, it sank 400 feet from shore. If something like that happens because of all of the complexity and all the interactions and all these pieces, if that happens, as you say, just 2 short years from now, the damage to the IRS and the impact on our country in that regard, not the health side, will be real and lasting. Thank you.
Thank you. This committee did research a Coast Guard ship that will crack in 2 in less than its first 20 years. So we're not completely beyond that at this time. Ms. Olson.
Chairman Issa, Ranking Member Cummings, and members of the committee, thank you for inviting me to testify today about the IRS's implementation of the Patient Protection and Affordable Care Act. As you know, my office is nonpartisan, so I take no position pro or con regarding the wisdom of the ACA. Rather, my focus has been and continues to be on trying to ensure that a taxpayer perspective is considered as the IRS prepares to implement the law as it stands today. In my 2010 annual report to Congress, I published a detailed assessment of the administrative challenges the IRS will face in implementing the 4 major tax provisions of the law. Since that time, my office has monitored the IRS's preparations for the ACA closely. Overall, I believe the IRS has done a good job of moving quickly to identify its key challenges and has taken significant steps to address them, although some concerns remain. On the positive side, the IRS has already issued considerable guidance to clarify gray areas of the law. I view the early publication of guidance as a very positive development because it enables both taxpayers and employers to know where they stand and to make informed decisions about their coverage options, and also to allow others to litigate against those state-taken positions. The IRS also has made progress in developing business requirements for computers and other information technology. IT infrastructure lies at the core of the IRS's ability to administer the program, largely because the IRS will use computer systems to communicate with the exchanges. Early systems development will allow for repeated advanced testing and enable the IRS to identify and fix glitches before the systems go live. My own organization, the Taxpayer Advocate Service, or TAS, has also been making preparations, including initial training of our employees on key provisions of the ACA, reviewing and commenting on drafts of published guidance, designing an online tool to help small businesses estimate the amount of small business health care tax credit they may receive, and conducting a survey of individuals and businesses regarding health insurance coverage and needs that will provide useful demographic information for outreach purposes. Notwithstanding these important steps, some areas of concern remain. First, the IRS and other entities need to step up their public information campaigns. The IRS should make it a top priority to work with other agencies to develop and deploy a targeted communications campaign designed to anticipate and answer questions from individuals and employers. As part of this campaign, the IRS should educate taxpayers who receive the advanced premium tax credit about the importance of updating information if their income or other relevant circumstances change. If the taxpayer continues to receive a subsidy but becomes ineligible, he or she will end up with an unexpected tax bill when eventually filing the related return. Most taxpayers otherwise are not required to provide periodic updates to the IRS, so this new procedure needs to be communicated clearly. Other remaining challenges include establishing smooth interagency communications, minimizing the impact of tax-related identity theft on eligibility determinations, and providing additional guidance for small businesses and employers. I also believe it is critical that the IRS begin to include representatives of my office on its implementation teams. Congress placed tasks within the IRS specifically to ensure that the IRS considers our taxpayer perspective as it develops and implements programs. And with any program, the devil is in the details, and if task representatives are not included on the teams where the details are hashed out, I'm concerned the taxpayers eventually will be harmed. On the whole, I believe the IRS will be able to successfully implement its responsibilities under the ACA, but I believe it is critical that the IRS receive adequate funding to meet taxpayer needs. If the funding is restricted, the IRS simply cannot cut spending on ACA implementation because unless Congress changes the law, administering the ACA is a statutory requirement. Rather, the IRS would have to make cuts in its taxpayer service and enforcement programs, and that would be a mistake. In my 2011 annual report to Congress, I identified the combination of the IRS's expanding workload and its shrinking resources as the #1 most serious problem facing taxpayers. I am deeply concerned that taxpayer service suffers the most when IRS funding is inadequate, and I therefore urge you to ensure that U.S. individuals and businesses that are trying to pay their taxes and are seeking help from the IRS are not shortchanged. Thank you for letting me testify today, and I'd be happy to answer your questions.
Thank the gentlelady. I now ask unanimous consent the 2010 annual report to Congress be placed in the record. Without objection, so ordered. The gentlelady mentioned a 2011 report. Do you have a copy of that with you?
I do not, but I can certainly get it to you for the record.
Then I ask unanimous consent that also be placed in the record. Without objection, so ordered. Professor, is it Jost?
Jost, thank you.
Jost. Then thank you very much. You're recognized.
Thank you. Thank you, Chairman Issa, Ranking Member Cummings, committee members, for this opportunity to address you today on the role of the Internal Revenue Service in health care reform. My remarks today specifically address Mr. Cannon's assertions, which he will be making shortly, that the IRS rule that permits Federal exchanges to issue tax credits is illegal. If Mr. Cannon is right, many constituents of committee members will lose tax relief that could give them access to affordable health insurance. Just for 2014, 1.9 million Floridians would lose $7.7 billion in Federal tax relief, 593,000 Indianans would lose $2.2 billion, over 1 million Ohioans would lose $4 billion, 2.6 million Texans would lose over $10 billion in Federal tax relief to help make health insurance affordable. Fortunately, Mr. Cannon's position is based on a misunderstanding of the law, its structure, and history. The exchange is fundamentally a market for health insurance, but exchanges will also ensure that health insurance consumers get value for money and access to premium tax credits. Section 1311 of the Affordable Care Act asks the states to establish exchanges, but Section 1321 authorizes HHS to establish a Federal exchange in states that choose not to, which is likely to include many states of members of this committee. Mr. Cannon believes that Federal exchanges cannot issue premium tax credits. This assertion was made earlier in this hearing because two subsections of Section 36B of the Internal Revenue Code, which establishes eligibility for tax credits, refer to, quote, persons enrolled through an exchange established by the state under Section 1311. Mr. Cannon argues that this means only state and not Federal exchanges can offer tax credits. The Affordable Care Act, as amended by the Health Care and Education Reconciliation Act, however, explicitly provides that Federal exchanges can issue tax credits. When I teach first-year law students how to read a statute, I tell them you start with the definition section. Section 1563C of the Affordable Care Act defines exchanges to mean, quote, an American health benefits exchange established under Section 1311. Section 1311 literally states that a state shall establish an exchange, and Section 1311D describes an exchange as an exchange established by a state. Because Congress cannot, however, constitutionally require states to establish exchanges, Section 1321C provides that the HHS Secretary shall establish and operate such exchange within a state, referring to the 1311 state if a state fails to do so. Under the Affordable Care Act's definition of exchange, a Section 1321 exchange becomes a Section 1311 exchange established by the state. This is reinforced by Section 1321 itself, which again refers to such exchange, referring to the earlier required 1311 required state exchange. Under ACA, therefore, all exchanges, Federal and state, are 1311 exchanges established by the state by definition. Other sections of the ACA direct all exchanges, Federal and state, to manage Federal tax credit functions, including Section 1413, which requires all exchanges to use streamlined applications and eligibility assessments to qualify persons for premium tax credits. Most importantly, a third subsection of Section 36B itself clarifies that premium tax credits are available through both state and Federal exchanges. This subsection was added to the ACA by the Reconciliation Act, which as a later adopted statute takes precedence over the original ACA if there were any contradiction. Mr. Cannon's interpretation is also refuted by the legislative history of the ACA as demonstrated in my extended remarks, which refer to repeated references to all states having premium tax credits available. Mr. Cannon claims to have found a statement by Senator Baucus acknowledging that only state exchanges could issue premium tax credits. I would be happy to introduce that colloquy between Senator Baucus and Senator Ensign into the record. It cannot be read to say that. Perhaps most importantly, the CBO and JCT have consistently assumed the availability of premium tax credits through State and Federal exchanges since 2009, and indeed the CBO's report from 2 weeks ago at footnote 14 explicitly recognizes that both Federal and State exchanges will issue premium tax credits. Finally, Section 36B of the IRC expressly grants the IRS authority to write regulations if there were any ambiguity in the statute. Under the Chevron doctrine, the IRS's interpretation of the statute would be accepted by the courts, as a recent Congressional Research Service legal analysis affirms. In sum, premium tax credits will be available to middle-income uninsured citizens of all of your states, not just Chairman Issa's and Mr. Cummings' states, which are going to have State exchanges. Thank you.
Thank you. And I would instruct the staff to get an official copy of that colloquy and ask unanimous consent to be placed in the record in the appropriate place.
Thank you very much, Chairman.
Without objection, so ordered. With that, we recognize Mr. Cannon.
Thank you, Mr. Chairman, and Mr. Cummings, and the members of the committee for the opportunity to present my views on the Internal Revenue Service's final rule concerning premium assistance tax credits in the Patient Protection and Affordable Care Act. I have submitted written testimony on behalf of my co-author, Professor Jonathan Adler of Case Western Reserve University School of Law, and myself. It is our contention that this rule exceeds the IRS's statutory authority under the PPACA and is an illegal tax increase. Two facts are key to understanding why this IRS regulation is illegal. First, both sides of this controversy acknowledge that the statutory language governing eligibility for tax credits is clear and unambiguous. The Act provides that taxpayers are eligible for tax credits if they purchase a health plan through, quote, an exchange established by the State under Section 1311, end quote. That language clearly authorizes tax credits only in state-established exchanges, and the Act employs or refers to that language no less than 6 times when authorizing tax credits. There is no parallel language anywhere in the statute authorizing the IRS to offer tax credits through Federal fallback exchanges established under Section 1321. The Act's authors intentionally condition tax credits on states establishing exchanges as one of a number of large financial incentives designed to encourage states to implement the statute. Even Professor Jost acknowledges that the provisions authorizing tax credits, quote, clearly say, end quote, those are his words, clearly say, those credits are available solely through state-created exchanges. Second, the remainder of the statute and the legislative history support the clear meaning of those provisions. The only statement anyone has found in the legislative history on this point comes from the bill's lead author and chief sponsor, Senate Finance Committee Chairman Max Baucus, who confirmed the bill conditions tax credits on states establishing an exchange. And yet, contrary to the clear language of the statute and congressional intent, this IRS regulation purports to issue tax credits in states that do not establish an exchange. Under the law's employer mandate, those illegal tax credits will trigger an illegal $2,000 per employee tax on employers and unlawfully appropriate hundreds of billions of dollars to private health insurance companies in states that do not establish an exchange. Since those illegal expenditures will exceed the revenues raised by this rule's illegal tax on employers, this IRS regulation will also increase Federal deficits by hundreds of billions of dollars, all contrary to the clear language of the statute and congressional intent. This IRS regulation is a large tax increase. It imposes a $2,000 per worker tax on employers and obligates taxpayers to pay for hundreds of billions of dollars of subsidies to private insurers. For every $2 of unauthorized tax reduction that will result from this IRS regulation, it imposes $1 of unauthorized taxes on employers, commits taxpayers to pay for $8 of unauthorized subsidies to private insurance companies, and increases Federal deficits by $9. Though this IRS regulation is nominally about tax credits, government spending accounts for 80% of its budgetary impact. Worse than a tax increase, though, this IRS regulation is an illegal tax increase. It lacks any statutory authority, it is contrary to both the clear language of the Act and congressional intent, and it cannot be justified on other legal grounds. It is quite literally taxation without representation. As you listen to the IRS and its defenders say that this illegal tax increase is consistent with the statute, or supported by the statute, or recognized through the statute, notice what they are not saying. In the years since the IRS proposed this regulation, they have not cited a single statutory provision expressly authorizing the IRS to do these things in Federal exchanges. because there is no such provision. They have not cited a single statutory provision that conflicts with the language limiting tax credits to state-created exchanges, because there aren't any. Nor have they cited a single statement from the legislative history that supports either this regulation's attempt to issue tax credits in Federal exchanges or their claims that it was Congress's intent that the Patient Protection and Affordable Care Act would do so. There is simply no plausible way to argue this IRS rule is consistent with or supported by congressional intent, much less the statute. The most important indicator of congressional intent is the text of the statute itself. That text is clear. It was there for all to see before Congress approved it. It is not possible that someone who read the bill could have mistakenly thought that that language authorized tax credits in Federal exchanges. The IRS should rescind this rule before it takes effect in 2014. Alternatively, Congress and the President could stop it with a resolution of disapproval under the Congressional Review Act. And finally, since this rule imposes an illegal tax on employers in states that opt not to create a health insurance exchange, those employers and possibly those states could file suit to block this rule in Federal court. Thank you.
I thank the gentleman. I now ask unanimous consent that our colleague, the gentleman from Tennessee, Dr. Rowe, be allowed to participate in today's hearing. Without objection, so ordered. I'll now recognize myself for a round of questioning. Professor Drost, is it undeniable that there's a cost difference between all states participating, some states participating, and the Federal Government essentially preempting the states choosing not to participate? In other words, if only 14 states participate, our scoring shows over $500 billion less in cost to the Federal Treasury. Would you disagree with that?
I would agree that citizens of all the rest of the states would be denied a federal tax benefit.
I will take that as, yes, it's $500 billion to the taxpayers, or more specifically, $500 billion we don't borrow from the Chinese.
Well, $500 billion that would not be granted in Federal tax credits to citizens of this country. Yes, thank you.
Mr. Cannon, when CBO scored this, my understanding is they made the assumption that all states would participate. Is that your understanding?
Pardon me, Mr. Chairman. There was a widespread assumption when this law was passed that all states would establish exchanges.
Okay, but states not participating has a ramification. Isn't it true that a state not participating means that a company would not get a $2,000 penalty plus the cost of the subsidy in that case if there's no state exchange?
That's correct. What triggers the penalties against employers under this law's employer mandate is when one of their employees receives a tax credit through an exchange. If there are no state-created exchanges, there can be no tax credits. If there are no tax credits,
so let me run through, because I now understand why Justice Roberts made the decision he made. Clearly, this was a pot full of taxes. We may disagree with whether it was right, but I begin to see why this is all about taxing, that Obamacare is all about taxing. So let me ask a question. Under a state that does not create an exchange, does the individual still have an individual mandate?
Yes.
Does the individual then have to seek either private insurance or the Federal exchange that is anticipated in the law?
Or pay a penalty tax.
Okay. So the Supreme Court decision that my colleague, the ranking member, referenced doesn't change. The states have the right to opt out under this law. They've chosen to do so in huge amounts, or at least not to participate, and it doesn't change anything related to the Supreme Court's question of the individual mandate. Is that correct?
That is correct.
So the challenge at the Supreme Court, which will occur when the tax is implemented, essentially the first time an employer gets this bill, he can then make a challenge that will go all the way to the Supreme Court, will be an all-new challenge that won't occur until 2015, correct?
That's actually not clear, sir. It is not, employers could file suit today, and it's a defensible, I think, perhaps the correct reading of the Supreme Court's ruling in NFIB v. Sebelius, that the Anti-Injunction Act might not bar an employer.
But certainly didn't bar on the other tax.
An employer establishing standing immediately.
But you'd say, and I think since Professor Jost only wants to answer the questions he wants to answer, not the ones I ask, clearly this is a separate issue that will very possibly go all the way to the Supreme Court. Is that correct?
I can't say how far it would go, sir.
Let me rephrase that. This is a separate issue which would be eligible.
That's correct.
Okay. Ms. Olson, you mentioned in our earlier conversation, I hope you don't mind my bringing it up, that your legal counsel, your general counsel, had made this decision from the rule, correct?
It's the Internal Revenue Service Chief Counsel, not mine.
Right,
yes.
but yours being the IRS.
Yes, correct.
That's a political appointee, isn't it?
Well, yes, it is.
Okay. So a political appointee made the decision that this rule should be made without, according to Mr. Cannon and my reading of the bill, without any legal standing. I'm going to ask you another question. This one concerns me more. In your 2010 report, you wrote, the new W-2 reporting requirements has raised numerous concerns that reporting the value of health insurance on employees' W-2 may cause the amount to be taxed. You wrote that. You also, in your 2010 report, which is in the record, you said, to get to the underlying goal of the new law, health coverage for the vast majority of Americans, will the, and this was a question, will the IRS audit every taxpayer who does not report? These are areas of concern you raised.
Yes.
Well, let me go through this. You raised it again. If you don't audit every single person to make sure that they properly were taxed, then we have a vast hole in which there could be subsidies paid, those shouldn't. There should be individual fines, taxes, if you will, $2,000 for those who don't. So essentially, you almost have gotten into a situation in which every American needs to be audited every year. That's more or less what you're saying there.
Sir, the first quote, we were saying there's confusion about taxpayers when they get information on their W-2 reporting what their premiums are. Should that be taxed? And the answer is no, that's not being taxed.
Sure, I understand you can explain part of it, but the other part is essentially, if you don't audit every American every year, then this thing won't be right.
The second issue was we were raising that as a concern, and if the IRS takes its normal approach, which is to select portions of the population to audit on any tax position, then you're not going to be able to effectively implement the mandate.
Okay, and I'm going to recognize the ranking member, but I just want to make it clear, it appears that the Commissioner made a political decision, which was the new W-2 reporting requirement has been delayed until after this presidential election, hasn't it?
I can't speak to that. I think the Commissioner is on the next panel.
Well, no.
I mean, there's been a delay.
There's been a delay, and the effect of that delay is that it won't appear for people to see until after this election.
That's a matter of fact, yes.
Yes, okay. With that, I recognize the ranking member.
To all of our witnesses, I really want to see this law implemented to its fullest degree, because I know that right now, right this second, there are people watching us. There's somebody laying in a sick bed that can't get up. There's somebody who cannot get insurance. And they're saying, you know, whatever you do, whatever arguments you got, get them straight because I want to live. And I want to speak for them because they're out there. And I've often said that we're all the walking wounded. All of us are the walking wounded. If we are walking yet and wounded, we will be. So, Ms. Olson, in your testimony, you're generally positive about what the IRS has accomplished to date. And you say that over the past 2 years, the IRS has used its time well. And I'm going to come back to you in a moment. And Mr. Everson, I want to thank you for your balanced testimony. But I want to ask you this. Considering, I mean, you were IRS Commissioner. We can do this. We can get this done. I know you highlighted a lot of issues that we need to be aware of, and I really appreciate that. And you're talking about some things that are perhaps preventive, hopefully, that is, so the IRS won't run into it. But we can get this done, can't we? This is America. This is the United States. We're a can-do nation.
Let me say this, sir. It's quite possible we'll get it done. The service is going to do its level best. The Commissioner, when you ask the Commissioner's question, he's going to say yes. Of course, he has to. His job is to implement the law, however strong or however flawed, so that he can't be then before the committee or before Ways and Means or Finance and have people say, well, you never liked this law. You said you couldn't do it anyway. So the service is always going to say yes. I think the service in this instance is a little bit like that frog they always talk about in the frying pan, that you keep turning up the heat until sooner or later the frog can't, is dead. It doesn't jump out. And that's my worry here, that there are so many pieces, there are so many things to do, especially on the system side, as has been indicated. On the reg side, there's so much confusion out there that I do worry about this. And then secondly, as you and I have discussed, I worry about the impact on tax administration from a failure here.
Yeah.
So I don't think this is going to be easy, and I don't think it's a certainty that it can be done, sir.
You said what? What was the last statement?
I don't think it's easy, and I don't think it's by any means a certainty that it can be done, even with very strong efforts by the IRS.
And with resources. I think that was one of the things that you talked about.
Yes, as I've indicated, absolutely give the service the resources it needs to do this if you're going to hold them accountable for doing it.
And thank you. Now, Ms. Olson, you also said you raised one specific challenge, and that was the need for a communications plan and a taxpayer education efforts. Why is that so important?
Well,
I agree with you, by the way. I think that's much needed.
we need to tell taxpayers, make sure taxpayers know where they should go for each step of this program, and that for the advanced premium credit, they're dealing with the exchanges. For issues on the tax return, they're dealing with the IRS. They need to update their information during the year so they don't get socked with the tax at the end of the year. And so we were talking about changing behavior, and we really need to communicate that information out there. To something else that former Commissioner Everson said, about the burden on the CPAs and other return preparers, I think we need to start talking to them about what to expect as we get closer to this date.
I don't know if you have read the GAO reports on the implementation of the Affordable Care Act, but they are also generally positive, Ms. Olson, about the IRS efforts to date. GAO finds that top IRS leaders have been directly involved in this process, and that IRS has accomplished a number of goals, and that the risks are being identified and analyzed at the individual project level. GAO also makes a number of specific recommendations to improve the implementation of the program. For example, GAO recommends that IRS develop an integrated plan with detailed cost estimates and develop procedures identifying and evaluating risk mitigation strategies. Ms. Olson, are you aware of GAO's finding? Are they consistent with yours?
Yes, and the IRS, I know, has responded to GAO's findings and is taking steps to address that.
And let me ask you about another report. This one is from the Treasury Inspector General for Tax Administration, and it is also fairly positive. It says that the IRS is effectively using tracking systems to monitor implementation, that is working on forms and publications and other consumer outreach, and that it has completed plans for computer programming tasks. And overall, the Inspector General says this: the appropriate plans have been developed to implement tax-related provisions of the ACA using well-established methods for implementing tax legislation. Do you agree or disagree with the IG's conclusion?
From what I have seen, I would have to agree to date.
Well, my goal on this committee is to conduct a constructive oversight and to work with you and the IRS to flag potential issues before they become problems. We will be having the IRS Commissioner on the next panel, and I'm looking forward to his thoughts, and I'm hoping that he has listened very carefully to what Mr. Everson has just said, and don't tell us what he thinks we want to hear, but tell us what we need to hear. With that, I yield back.
I thank the gentleman. We now recognize the distinguished gentleman from Tennessee, Dr. Desjardins, for his questions.
Thank you, Mr. Chairman. What we need to decide today is whether the IRS bypassed Congress, in a sense, wrote a new tax law that is a power given solely to Congress. So let's go through first a series of yes/no questions. I know panels tend not to like those, but let's try to do the best we can. First, Mr. Cannon, is there anything stopping the IRS from implementing Section 36B of the Internal Revenue Code exactly as written?
36B is large and complicated, sir. If what you mean is the provision restricting tax credits to state-run exchanges, no.
Thank you. Mr. Jost, Professor Jost.
36B, as I explained, if you read the definitions, does authorize Federal exchanges to issue a tax credit. So, no, there's no problem.
There's no problem. Thank you. In one part of the law, it authorizes tax credits for people who purchase a qualified health plan through an exchange established by the State under Section 1311. And even people who defend the IRS on this issue, such as yourself, Professor Yost, say that this part of the law is clear. Is there any part of the statute that prevents you from doing just that, offering tax credits only in State-run exchanges?
Again, the definitions.
Mr. Cannon, is there any part of the statute that prevents you from doing just that, offering tax credits? No. Okay.
No, in fact, the statute requires that.
Okay. Is there any part of the statute that conflicts with that, Mr. Cannon?
No, in fact, all other elements of the law support the clear meaning of that limitation of tax credits to health insurance exchanges. It's established by the State under Section 1311. And established by the State. Those words are key.
What about the information reporting requirement?
That does not conflict. It does require exchanges established by under Section 1321 by the Federal Government to report information related to eligibility for tax credits and the advance payment of tax credits to the Treasury Secretary and to individuals enrolled through those exchanges. Okay. But that does not conflict in any way with the limitation of tax credits to State-run exchanges.
Okay. So what is stopping the IRS from implementing the tax credit provision exactly as written and the exchanges from implementing the information reporting requirement exactly as written? Or can they both be implemented exactly as written without conflicting with each other?
The latter. They can both be implemented exactly as written without any conflict.
Agree, Professor Yost?
I would agree because, again, Federal exchanges can issue premium tax credits and can report.
Okay. Do you agree that when authorizing these premium assistance tax credits, the Internal Revenue Code explicitly refers to only health insurance exchanges as established by the States under 1311? Professor Jost?
I do, and again,
Mr. Cannon?
Given the definition, that means Federal exchanges.
Okay. That is what the statute says, but I would disagree with Professor Jost that the Federal Government can establish a health insurance exchange established by the State, which is what Section 1311 requires, and that claim is completely inconsistent with the text of the law.
Okay. Simple question. Do you agree that when authorizing those tax credits, the IRC reportedly refers to exchanges established by the State under 1311?
That's correct.
Professor Jost, do you agree with that? Repeatedly refers.
Again, given the definition, that includes Federal exchanges.
Okay. Do you agree that the ruling providing tax credits in Federal exchanges will trigger penalties against employers under the employer mandate in States with Federal exchanges? Professor Jost.
If they do not offer health insurance or adequate or affordable insurance and their employees go into the exchange and get Federal premium tax credits, yes.
Mr. Cannon, yes or no? Yes, thank you. Are you aware, Professor Jost, are you aware of how many times the reconciliation bill, the Health Care and Education Act, amends Section 1401 of the Obamacare law, which created IRC Section 36B, authorizing the tax credits in State-created exchanges?
Well, at least once, but I don't know off the top of my head.
7 times. Are you aware of how many times that some reconciliation bill, that the same reconciliation bill amended Section 1402 of the Affordable Care Act, which authorizes cost-sharing subsidies credits in State-created exchanges?
Not off the top of my head.
Okay, 5 times, so a total of 12 times. So if Congress intended to offer tax credits and cost-sharing subsidies through Federal exchanges, then why didn't Congress include any language to that effect among the 12 amendments within the reconciliation bill authorizing tax credits and cost-sharing subsidies through exchanges established by U.S. territories? Is that a coincidence?
Again, it had already authorized Federal exchanges to issue tax credits, and therefore there was no need to amend it.
Mr. Cannon, do you agree? Is he going wrong?
I don't. There's no language authorizing tax credits in Federal exchanges, and the claim that Professor Jost is making is not supported by the text. What he's saying is that the Federal Government can create a health insurance exchange for purposes of Section 1311. But Section 1311 itself clearly says that for purposes of that section, quote, an exchange shall be a governmental agency or nonprofit entity that is established by a State. It's simply implausible to argue that the Federal Government can establish an exchange that is established by a State.
In fact, we know it was their intent to entice or almost coerce States into signing up for these exchanges. They thought that when Obamacare is released, the states would just line up and sign up for these exchanges. But when they didn't, they realized they had a real problem. But the intent of the bill was clear. That's what they were trying to do. Do you agree?
And that intent was revealed by Senate Finance Committee Chairman Max Baucus when challenged by opponents of the bill in his committee. He said that it does condition tax credits on the creation of a state exchange,
and this
on the state creating an exchange.
The gentleman may finish the answer if he wants. Okay. You're done.
Yes.
The gentleman's time has expired. I thank you. We now go to the gentleman from Illinois, Mr. Davis, for his questions.
Thank you very much, Mr. Chairman. I want to thank the witnesses for appearing also. Ms. Olson, opponents of health reform legislation have unfairly characterized the Affordable Care Act as resulting in, and I'm quoting now, an unprecedented expansion of the IRS powers. To be honest, I'm not exactly sure of what they're talking about. So let's look at some of the possibilities. One claim they appear to be making is that the IRS has the new authority to distribute billions of dollars in tax credits to individuals purchasing health insurance on the exchanges. I think that's a good thing, but it seems that some of my colleagues on the other side of the aisle do not. Ms. Olson, does this aspect of the Affordable Care Act represent an unprecedented expansion of the IRS powers, or does the IRS have decades of experience with distributing funds as part of similar social programs, like when the IRS distributed the Bush administration's economic stimulus payment? Another claim that opponents of the law are making is that the IRS will have access to individuals' personal health information when they are verifying insurance coverage. Are these accurate assertions?
I view ACA not as an unprecedented expansion of IRS powers, but rather an unprecedented expansion of IRS work. The powers that we have in the law are powers that reside in tax administration, period. We implement the Earned Income Tax Credit, which is billions of dollars, the first-time homebuyer credit, as you referenced, the economic stimulus payment. We are a disperser of payments, and that trend has been happening since the 70s. In terms of health insurance, health information that we would get, my understanding is that we would get the information from insurers whether or not the taxpayer was covered, and essentially nothing else, the amount of the premium paid. And that would be it, nothing about their state of health or anything like that. That is new information that we will be getting, however. However, we have always been getting information from third parties. So it's not a new approach giving us information. It is new information.
Well, let me proceed. A number of people appear to still believe that the IRS will be subjecting individuals to liens or levies or even jail time if they fail to purchase insurance. Is this from your analysis?
No, the law, at my urging, in fact, prevents the IRS with respect to the individual mandate, what people call the individual mandate. The IRS is prevented from issuing liens or levies or its other enforcement action. It can collect that mandate through what we call a refund offset, where a taxpayer has a refund coming to them, and we would offset that refund amount with the amount of the penalty.
And if low-income taxpayers cannot afford health insurance, will they be subject to a penalty?
There are many provisions in the law allowing for exemptions both for hardship, and the mandate only applies to taxpayers starting at a certain level of income.
Some folks have claimed that the Affordable Care Act will require the IRS to hire 16,000 new enforcement agents. The Commissioner has said on a number of occasions that this is a made-up number with no basis in fact. Is this your understanding perhaps as well?
I think the Commissioner can certainly speak on the next panel about this. The internal conversations, my understanding is that we're maybe looking at going forward 800, 860 full-time equivalents for doing this work once it's implemented.
Thank you very much. My time has expired, Mr. Chairman, and I yield back.
I thank the gentleman. I now ask unanimous consent that Professor Joyce, September 11, 2011, article, yes, the Federal Exchange can offer premium tax credits, be placed in the record. Without objection, so order. Professor Joyce, my staff has asked me to give you an opportunity to clarify an answer you gave to Dr. Desjardins. You said that it was in the Act. In the September 11th, you said it was a drafting error. Can you reconcile, is it in the Act in written language, or in your September 11th, 2011 article, were you correct that in fact it was clearly left out of the Act?
I have learned over the last year a bit more about the statute, and that is something that I think is worth doing. I think the statute could have been better drafted, but I think if you read the statute as a whole, including the definitions, it does authorize Federal exchanges, and I was wrong at that point.
Okay, so you're saying 2011 is incorrect, the article, and you now stand by your testimony?
That part of the 2011 article was incorrect, and I now stand by my testimony. Thank you.
Thank you very much. We now recognize the gentleman from Michigan, Mr. Walberg.
Thank you, Mr. Chairman. And I think the insertion of the music at that proper time was probably coming from the sovereign of the ages, saying that we're living in a fantasy world, that this thing is going to work. And so maybe that music will come in again at some time. As I understand, from what I hear and what I read, what I've heard today, that tax credit eligibility and size are determined by a formula that includes a number of things, details. The tax credits are sent directly from Treasury to health insurance companies. Ms. Olson, you've stated that, and I quote, taxpayers who did not update their household information during the year may find that they owe a significant amount of money at the end of the year, money they likely do not have. I would concur with you in that statement, at least my concerns would concur with you. What type of information will households have to update?
They will, if they are determined by the exchange in advance that they are eligible for these advance payments of their health care premium, they will need to let the exchanges know if they have gotten an increase in salary, because that may make them ineligible for the full amount of the credits that they're getting. On the other hand, if they have a child may become ineligible in their household, someone may die in their household. On the other hand, they may be entitled to more credit if they get unemployed or something like that. But the point is, it's the changing of their circumstances, and that they're going to have to update it during the year, and that they could end up owing money at the end of the year is a risk, and I'm very concerned about that.
And even with different states, changing states, as many people have to do to just find a job now, changing states with different provisions in their exchanges could make it very difficult as well.
It could very well be.
Do you think, and I come from the aspect, that if you're a person who has to file a quarterly report, you understand the complexities of that. But if you have a bunch of new citizens who are going to be really required, if they're going to be intentional about it and not run amok, are going to be filing reports that they've never done before and don't have the abilities of external resources to help them, the challenges that will be there. Do you believe that most Americans are going to update the IRS or state exchanges when they change jobs, get married, move states, whatever?
I think it's going to be a very great learning curve.
With a lot of pitfalls.
With a lot of pitfalls. The only saving grace is about 80%, 75 to 80% of taxpayers get a refund. So it's unlikely that they will owe money to the IRS. It's just that their average refund is $3,000. That at least the first year their refund might be, decreased. And I'm not minimizing that. That's a significant thing for taxpayers.
And the confusion, especially at the first reconciliation in 2015,
yes,
is going to be.
I think it will be a surprise to taxpayers if they don't update their information.
And persons who are in a situation where they are now having to use a government-run health care or government takeover of health care are not only going to have the sickness and the problems that they have, but also the confusion, the frustration, the worry, in some cases the terror of trying to deal with all this while they're trying to get well.
I think the agencies are trying to make it as easy as possible.
Okay. Thank you for your responses. Mr. Everson, many experts point out that the tax credit most similar to Obamacare's premium tax credits is the Earned Income Tax Credit. Unfortunately, the EITC has an extremely high error rate and fraud rate, sadly. What lessons are there from the EITC experience and the IRS that the IRS can take to reduce the error rate and fraud rate with premium credits?
Well, the program, sir, is very complex, and it's distinguished from many other Federal programs where there's a real front-end application process where you sort of sort through information and then someone is deemed ineligible or eligible for a benefit. There's no administrative cost to the EITC in the sense that most big food stamps or other Federal programs, they've got a 6 or 7% of the monies that are appropriated go to administering on the front end. The EITC is by and large like other things on your return. You put it out there, and then if the service has questions, they hold a lot of the returns before they pay because, as you indicate, there's a lot of fraud. There's a lot of just plain misunderstanding, even more of that gets in there, and that's a real problem. But I would say the biggest piece is the complexity and the service.
So Obamacare is more complex than EITC and other.
I agree with the advocate's comments earlier that it's about a lot more work, but it's about also very great complexity within each of the many provisions that are in the statute. So I consider this comparable in many ways, yes I do, to the EITC. And so the problems, the EITC, at least when I was Commissioner, had the highest error rate of any Federal program, and I believe it still does.
And this is more complex.
Yes, I think it is.
Would the gentleman yield for just 1 second?
I would yield.
I just want to verify, Ms. Olson, you were saying that individual taxpayers would have to update their record if there had a change. What year will be used by the IRS initially to determine in 2014 what the subsidy will be? I don't want an open question.
Right.
I just want to make sure here this is clear. 2012
income is what is used to determine your eligibility for a premium, advanced premium payment for 2014.
Thank you. Just to make sure they got in the record. I thank the gentleman. With that, I recognize the gentleman from Massachusetts for 5 minutes.
Thank you, Mr. Chairman. Thank all of our witnesses today for their testimony and their knowledge on this thing. Professor Jost, I just wanted to ask a question about the fact that until recently, a lot of the insurance companies were spending, I believed, a significant amount of their premium money on things other than health services, whether it be salaries or bonuses or lobbyists or other administrative costs. One study, in fact, indicated that 10 of the largest insurance companies saw their profits jump some 250% between 2000 and 2009. In just 2009 alone, at the height of the economic recession, the 5 biggest insurance companies saw their profits increase by 56%. So I find that a startling figure. But I wonder if you have any idea how these health insurance companies were able to increase their profits so dramatically during that time.
Yes, I do. The medical trend, the growth in health care costs, has been growing at historically low levels for the last 2 or 3 years. Nevertheless, insurance companies were increasing premiums because they believed that once the recession ended, people would start using more medical care and trend would go back up. So there has been a growing gap between premiums and actual health care costs. The medical loss ratio 80-20 rule that the Affordable Care Act imposes has resulted in 12.8 million Americans receiving $1.1 billion in rebates that were due as of yesterday, including $300 million in rebates for American small businesses. Yet insurance companies are still doing very well. I was just reading this morning, Carl McDonald says that Cigna beat expectations and that most insurance companies in their most recent quarterly reports that were just issued beat expectations. So we have a solution where premiums are coming down, Americans are getting rebates, insurers are still doing just fine.
Well, thank you. I'm glad to hear that. I was responsible for putting that provision in the House bill when it went through the education hearings on that, and this is the expected and anticipated result that we thought, and so it's good to know that your remarks coincide with what the Secretary has told us as well, and what I think a number of reports have done that. Mr. Joseph, Professor Joseph, again, the IRS issued their final regulation allowing the premium tax credits to be available to all people regardless of the origin of their exchange participation. Is that right?
That's correct.
Okay. So Mr. Cannon made his argument that the rule constitutes a net tax increase. I assume that you don't agree with him on that.
No, this is a tax cut.
Right. And under the interpretation of the Affordable Care Act that Mr. Cannon puts forward, residents of states with federally operated exchanges wouldn't qualify for the premium assistance tax credits. So I want to give you another opportunity, just rather than passing your opening remarks on that, to explain what the cost of Mr. Cannon's interpretation would be to taxpayers who do not get their tax credits.
Well, it's hard to know exactly. I mean, there are going to be $1 trillion in tax credits over 10 years, and it looks like initially probably 30 or 40 states are going to have federal exchanges. So all of the residents of those states would be denied premium tax credits.
So the National Health Interview Survey just released this past Tuesday says that more than 1 in 5 middle-aged United States adults and nearly half of the adults over the age of 65 have more than one chronic health condition, whether hypertension, diabetes, things of that nature. There are more and more people every day that need assistance in managing and preventing those diseases, and yet 50 million people are without access to health insurance. So, Professor, can you explain what the impact will be on those individuals of the exchanges coming into effect in 2014?
Well, a report done by the Harvard Medical School a couple of years ago projected that about 45,000 Americans die every year because they are uninsured. Making premium tax credits available to 20 million Americans so that they can afford health insurance is really a question of life and death. It's going to be Americans whose lives are saved because they can get premium tax credits, and in many states that means initially premium tax credits through the Federal Exchange.
Thank you. I yield back, Mr. Chairman.
I thank the gentleman. We now go to the gentlelady from New York, Ms. Burkle.
Thank you, Mr. Chairman, and thank you for this very important hearing. And thank you to our panelists for being here today. I graduated from nursing school a very long time ago. I was one of those diploma grads and spent time doing clinical nursing. And then when I was 40, I decided to go to law school. And for 13 years before I came to Congress, I represented a large teaching hospital in upstate New York. Now, so pretty much my professional career has been spent in health care. And one of the reasons I ran for Congress is because I thought the direction of the Affordable Care Act was incorrect. Now, I do want to make one point, and that is my colleague on the other side of the aisle mentioned we are opposed to health care reform. By no means are we opposed to health care reform. But I would have thought in a health care reform and in a nation that wants to make sure people have increased access to health care, decrease the cost of health care, that we would have seen tort reform, that we would have seen the increased use of health savings account, that we would have seen the ability to buy insurance across state lines, portability, increasing the number of physicians and encouraging them to go into the cognitive, into the family practice and the internal medicine fields. But we don't see any of that. And I sit here and I think, have we lost our way so much in this city that when we talk about health care reform, we have to bring in the IRS and talk about raising taxes on the American people by $500 billion. Who in their right mind thinks that what we're talking about here today is going to increase access to health care for the American people or decrease the cost? Who has gotten so far away from reality down here that they think this is the way we help the American people? And when my colleague talks about that patient laying in his bed needing health care, if you think that going to the IRS and dealing with the IRS is going to increase your health care, your access to health care, or decrease the cost, or improve the quality of health care in this nation, we have a problem in the United States of America. I am sitting here stunned. I've paid such close attention to this. All of my colleagues have. And I sit here and I think, what in God's name are they talking about, and how is that going to help that senior citizen understand her benefits, make sure she's covered, make sure that person who's unemployed has access to health care? This is gibberish. We're talking about the most intensely personal issue for the American people. Health care. Health care is so important to every person in this room. It affects how they live their lives. And we are talking about an agency, the IRS, and I know firsthand from the complaints that come into my office how difficult it is to deal with the IRS, how unresponsive the IRS is. And now you take the IRS and it's not just going to be your income tax any longer. It is going to be, well, I've had a baby. Oh, I've lost my job. I've gotten a promotion. All that now has to be communicated to the IRS. The American people and this health care system that's been created in the Affordable Care Act, the largest tax on the American people in the history of this nation. If one person can tell me in this room how that is going to improve our health care system, how it's going to improve access to those who need health care, and how it's going to decrease the cost, I welcome the explanation, but I fear for the American people that this Affordable Care Act is going to dramatically affect their access to health care. It's going to dramatically affect the cost of health care. It is going to put us into a single-payer system, which I believe was the ultimate goal of the Affordable Care Act. This does nothing to improve the free market. Let the free market decide what system works best, not the Federal Government. We are in trouble when we sit here and we have a discussion that this is the best way to go for the American people. This is the best we can do to make sure that the American people have health care coverage. I see my time has run out. Mr. Everson, if you could comment. Just briefly, we've had unemployment at over 8% for the last 42 months. How is this going to impact our businesses in this nation?
Well, in terms of the health care piece, is your question? I do think that the difficult economic circumstances make the challenges that the advocate has spoken to of the constant updating of the information an even more daunting task as we go forward. The interactions that you've spoken about that are necessary with the service, and then the complexity, the confusion, the fact that the person is going to be going in and seeing the exchange, seeing people in the exchange or talking to the exchange and then being told, well, the IRS says you're not eligible. The IRS says you already have this or that. That is all going to converge in a situation where a lot of people, as you indicate, are already under stress because of difficult economic circumstances, or maybe they don't have a job. So I think that the circumstances of the country right now make it inherently more difficult.
Thank you, Mr. Chairman. I yield back.
I think the gentlelady's time has expired. We now go to the gentlelady from New York, who has been patiently waiting. Ms. Maloney.
Thank you, Mr. Chairman and Mr. Ranking Member, my colleagues, and all of the panelists. Mr. Cannon, I understand that your reading of the Affordable Care Act is that it does not permit the IRS to provide premium tax cuts or tax credits to individuals who participate in health insurance exchanges administered by the Federal Government. In fact, I believe you called this illegal. Is that correct?
That is correct.
Well, the Congressional Research Service has come out with a report on this, their own legal analysis, and they have examined this issue, and it did not come to the same conclusion. And according to the report, which I would like unanimous consent to place in the record, according to the report, it says—
Without objection, so ordered.
Thank you so much. It says on page 8, and I quote, "The IRS rule appears to be an exercise of the authority delegated to the agency to implement Section 36B, which includes the authority to provide refundable tax credits for taxpayers enrolled in a health insurance exchange." End quote. Have you read this report, or have you seen this report?
I'm not familiar with that. On what date was that released, may I ask?
This says July 23rd.
I'll have to review that.
Okay, great. Or we can get you a copy.
I can comment on that claim if
But
you're
first, I'd like to read other portions of it, too. And the CRS also reports, it says, thus, if a reviewing court, and I'm quoting, determines that there is an ambiguity surrounding the issue of whether premium credits are available in Federal exchanges, the regulations issued under Section 36B, the regulations will very likely be considered a reasonable agency interpretation of the statute and accorded deference by the court, end quote. Now I'd like to turn to Professor Jost, if I could. And Mr. Jost, you believe Congress provided the IRS authority to provide premium tax credits to individuals who participate in the Federal exchange.
That is correct.
And why did you come to this conclusion?
Well, again, because of the definitional sections of the statute and the way those work together, because of the structure of the statute, and because of the legislative history of the statute, in which Congress, senators repeatedly said that tax credits would be available in all states.
Well, do you agree with the interpretation that I just read from the Congressional Research Service?
Yes, I do.
And Mr. Jost, do you also agree with CRS that it's very likely, and I quote, very likely that a court would defer to the IRS's interpretation of the statute?
That's correct.
And on the substance, why was it important for Congress to give the IRS this authority?
Because Section 36B is, as has been said a number of times, a complicated provision that requires interpretation and requires application. And the IRS has done an admirable job of putting out regulations that, with lots of examples in them, to help people understand how this section is going to work.
Well, thank you. And I think you gave a clear indication why this is important and why it matters. So I yield back the balance of my time.
I thank the gentlelady. We now go to the gentleman from South Carolina, Mr. Gowdy, and I would ask the gentleman, would he yield me 10 seconds for a question?
I would yield whatever time the Chairman wants.
Thank you. Mr. Cannon, do you know of any member of Congress, either side of the aisle, who said that Federal exchanges would have subsidies prior to the passage?
Mr. Chairman, my staff and I did a pretty extensive search of the congressional record, including markups and committee action on this statute. We found only 2 mentions in the congressional record of what would happen if states did not create a health insurance exchange on their own. The first was the chairman of the Senate Finance Committee said that tax credits are conditioned upon states establishing their own exchanges. So that affirmed
Barney Frank.
Clear meaning. No, I'm sorry, the chairman of the Senate Finance Committee, Max Baucus, who is the lead author of this law. So that confirms the clear meaning of the statute. The only other mention was in the House, during House consideration of the Patient Protection and Affordable Care Act, by Congressman Michael Burgess. He said, what happens if states don't create an exchange? Well, a federal exchange will impose a public option. It made no mention of tax credits. Those are the only two we have found, and Professor Jost and the IRS have not cited anything from the congressional record or the legislative history that other than the idea that all states would be establishing their own exchanges. There's nothing that anyone else has offered that suggests that if a state does not establish an exchange, the tax credits would be available in federal exchanges.
Thank you. Clearly, the GSA had a mind reader at its convention. Perhaps the IRS does too. Thank the gentleman for yielding.
Yes, sir. Speaking of mind readers, I was going to ask you, Mr. Cannon, a similar series of questions. It appears the professor is relying on a definitional section and without putting everyone in the audience to sleep with rules of statutory construction. The last statute takes precedence over previously passed one. All provisions must be read in harmony if they can. All the other stuff that made us very anxious to get out of law school. Why is he wrong?
The professor makes the claim that the statute treats state and federal exchanges equivalently. It does not. It refers to exchanges under Section 1311 as I quoted before, an exchange shall be a governmental agency or nonprofit entity that is established by a state. So that is clear that they're not talking about an exchange that is established by the federal government. The section authorizing tax credits likewise is clear. It says those tax credits are available only through, quote, an exchange established by the state under Section 1311. Senator Baucus's original bill had language similar to what Professor Jost cites. It said the Secretary, if a state doesn't establish an exchange, the Secretary shall, quote, establish and operate the exchanges within the state. And Senator Baucus confirmed that tax credits would, under that language, would be available only in states that establish their own exchange. Furthermore, the statute itself does not address, or the information reporting requirement that Professor Jost cites in his other argument refers to Section 1311 and 1321 exchanges separately. If every time the federal government referred to a Section 1321, if they were equivalent, there would be no need to refer to them separately. And the Finance Committee bill, which is what became the final law, was different from the bill that was reported by the Senate Help Committee and the bill that was reported by the House in this very important way. Both the Help Committee bill and the House Committee bill had explicit language saying that state and federal exchanges are equivalent. They drew an explicit equivalence between exchanges created by states and exchanges created by the federal government. There's no such language in here. The definitional section that Professor Jost mentions does not establish that equivalence.
Mr. Everson, what new citizen information will be available to the IRS that is not currently available to them?
Well, I think, sir, that the statute contemplates getting into any number of areas that are non-financial. It's true that, as has already been pointed out, it's not medical information, and that's important. But you're going to be asking businesses to report on their plans and details of their plans so that the service can determine, or it can be determined, whether they qualify as meeting needs under the statute. And then you're going to have individuals who will, as was indicated earlier, they're going to have to constantly update information about the status of employment and whether they have coverage or not. So I think can't be said enough that this need for updating and timeliness is a very real change for taxpayers that's important, in addition to the new areas beyond purely financial information that you are, as a taxpayer, are used to already providing.
Back in the good old days, we used to have to get a court order just to get a tax return from somebody we were about to indict. What level of independence, disclosure, confidentiality will exist with this new information?
Well, I think that that's something that the service is best capable of answering. The service historically provides great importance to the protection of taxpayer information. My concern is that there are already real protocols that exist through working with a state taxing authority. I'm from Indiana, and working with the Revenue Department there, or with major cities to share that information. Everybody's used to doing that. These exchanges are going to be in the process of being stood up
over a period of time, they're going to have enough they're dealing with, and then yet they're going to be charged with protecting this information as well. You get a lot of problems with disgorging of taxpayer information or information generally. I think there's not a week that doesn't go by where a credit card company or a business doesn't talk about hundreds of thousands of records being just spat out. And you're introducing a lot of new players here, so while there may be protocols, getting that working is going to be very challenging and I would say fraught with problems. The last thing I'll say on this is I worry about the WikiLeaks parallel where you get not an error of the system, but an individual who has lots of records and says, I don't like this law, or I don't like elements of this, or I'm not, so-and-so the companies didn't provide what had to happen, and the individuals do the wrong thing. There's a lot of risk here, sir.
Thank you, Mr. Chairman.
I thank the gentleman. I'd ask unanimous consent pursuant to the gentlelady from New York's entering into the record the congressional research study of just a few days ago. The Ways and Means has forwarded a specific line in answer, and I quote, applying the plain meaning rule to Section 36B, it is possible that the Court could read the phrase, parentheses, an exchange established by the State under 1311 of ACA, unquote, as being clear to not include an exchange established by the Federal Government. I just want to make sure we made it clear that was actually the verbatim of that report. And with that, I recognize the gentleman from Virginia, Mr. Connolly.
Thank you, Mr. Chairman, and thanks to our panelists for being here. Mr. Everson, in your testimony, did I understand you to say that your concern is that the involvement of IRS in a major non-tax administration initiative has the potential to erode the independence of the IRS? Is that correct?
That is absolutely true, sir.
Ms. Olson, do you share that concern?
I think that the IRS needs to not be viewed as a political or politicized agency.
Does the assignment, however, here from the ACA, in your opinion, compromise or potentially compromise the independence of the IRS as indicated by Mr. Everson?
I think the IRS will conduct itself in a way that it will not be compromised.
The IRS currently or recently has had, for example, assignments like the economic stimulus payments, the earned income tax credit, the first-time home buyers tax credit, and the making work pay credit. Is that correct?
Yes.
Did any of those, the administration of any of those, compromise the independence of the IRS?
The IRS implemented the law as it understood it.
Did it compromise the independence of the IRS?
In my opinion, no.
Mr. Everson, in your opinion, did they compromise the independence of the IRS?
I believe that the items you're citing are pretty well within the bailiwick of traditional tax matters for the service. What I think you have here is the potential that comes from a major administration initiative. And again, I'm making this context outside of politics, and I'm not making any substantive allegations. I'm talking about potential systemic risk.
I understand.
And so I'm not seeing it, but I think that this is quantifiably different than anything the service has done.
Mr. Everson, yes. Unfortunately, I only have 5 minutes, so bear with me here.
Okay, go ahead.
Thank you. But let me ask this.
Yeah.
In light of the Supreme Court ruling, Chief Justice Roberts' ruling,
yes,
in that horrible word of the tax, doesn't that in fact add more weight to the role of the IRS, not less?
No doubt it does. That's right. But I am drawing.
If I can, Mr. Evans, but it seems to me to put to bed a little bit the concern you've got, maybe not for you personally, about independence of IRS when the Chief Justice of the Supreme Court and a majority ruling of the Supreme Court says otherwise. That it most certainly is within the purview, in fact, the responsibility of the IRS by virtue of his decision of what constituted the constitutionality of the Act.
Well, clearly that's justified the operation of the individual mandate, yes.
Thank you. But, I'm sorry, but
no, that's okay. Go ahead.
I have a limited period of time here.
We obviously disagree.
I understand, yeah. but we have a Supreme Court ruling now. And God knoweth why, but they didn't invoke the Commerce Clause, they invoked something else. So there we are. Professor Jones, are you familiar with ObamaCare in Massachusetts?
I'm familiar with the Massachusetts reforms, yes.
Well, it seems to me if we're going to call the ACA Obamacare, we'll call health care reform in Massachusetts.
I don't, so I'm trying to be even-handed.
I understand. I'm trying to be even-handed, too. What's the role of the Massachusetts Department of Taxation, which is the analog in Massachusetts? I happen to come from Massachusetts originally. What's the role of the Massachusetts Department of Taxation in the administration of this particular set of issues in RomneyCare?
I believe there are premium tax credits in Massachusetts.
Really? And when fines or penalties are imposed, as they are under the law signed into law by the governor of Massachusetts at the time, Mitt Romney, how is that administered? I mean,
through the tax system.
Through the tax system. Is it not virtually identical to the system Ms. Olson described that will pertain to the ACA?
The ACA was modeled on the Massachusetts health care reforms.
So, for example, as Ms. Olson was justifying a little bit earlier, most people have a refund, and you'd net out the refund if you owed that fee. Is that correct?
I believe so.
And is that not exactly how Massachusetts works?
I believe so.
Ms. Olson, is that your understanding as well?
I am not an expert on Massachusetts. I can only speak about the federal provision.
I see. Final point, maybe Ms. Olson, to you. There's a return for every dollar we invest in the IRS. Is that not correct?
Yes.
And is it my understanding for every dollar IRS got, it produced $200 in revenue?
That is the ratio of what we collect to our appropriated funds.
So given our obsessive concern about the fiscal situation and the national debt, Congress has in fact increased IRS's budget given that ratio so we can collect that which is owed. Is that not correct?
You're still working on our appropriation this year, so.
What's happened in the last 3 or 4 years?
Actually, last year our budget was decreased.
Decreased?
Yeah.
And what's the total amount of revenue owed the government, not new taxes, that's left on the table every year because of lack of collection?
It's about $359 billion or something in that range.
$359 billion a year. Now, if I multiply that times 10, that would be over $3.5 trillion. Is that correct? And your understanding of the value of the sequester we're so concerned about, but we're not going to cancel our 5-week recess to do anything about, is $1.2 trillion. Is that not correct?
I'm sorry, I'm not following your question.
The value of the sequester we're worried about is $1.2 trillion. Is that not correct?
That's my understanding.
And the amount you're talking about over that same period of time would be 3 times that. I thank the Chair.
Thank you. The Chair now recognizes the gentleman from North Carolina, Mr. McHenry.
Thank you, Madam Chair. Look, Americans know that the tax code is complex. That's obvious to even those that don't pay taxes. I mean, I think it's one of the self-evident truths that American people have. And I've run into an issue in western North Carolina dealing with small fire departments. I've got 6 to 8 of them that, based on a provision of law and how the IRS chose to implement it, means that these volunteer fire departments, they're quasi-governmental nonprofits. They receive taxpayer funds, and they actually have tax collection areas. We have this whole thing. And so my office has had to be engaged in making sure that these nonprofits still get to maintain their nonprofit status based on how the IRS has implemented it. And so, there's a lot of grief the American people have with the IRS, and we've got public safety at risk based on how the IRS has chosen to implement a law. And so, I want to say, Ms. Olson, your office, the National Taxpayer Advocate Office in Greensboro, has been enormously helpful to us in going through this whole process and trying to be truly a taxpayer advocate for these volunteer fire departments in my district. And I want to thank you for that. This has been enormously frustrating and confusing, but I certainly appreciate the work that you do and the work that your staff does. Thank you.
Well, thank you, sir. I am personally very familiar with that issue, and it is on my radar screen, and we are working on this.
Well, thank you. I certainly appreciate it, and I hope that the Commissioner hears this as well, and that you have some compliance on behalf of taxpayers. The IRS actually has some compliance. To that end, and the reason why I bring this up is because it's about the confusing and complex nature of the tax code, and that is frustrating as it now stands. That's before we even talk about ObamaCare's. My colleagues on the other side of the aisle like to call it affordable health care or whatever else, anyway they want to call it. But the point is, if you look at how the IRS is going to have to implement ObamaCare and portions of ObamaCare, Mr. Everson, you've testified well on this. So in your testimony, you expressed doubt as to whether the statutory scheme enacted into law is even workable mechanically. What do you mean by that? Explain. The IRS has a complex enough code. Are you saying that this is even beyond?
I'm suggesting that there are so many parts and there are so many players that we cannot by any means be sure that this is going to work. That's not getting at the policy objections that some have raised. It's just simply as a matter of management. That's particularly the case because of the fact that there are different levels of government. You've got different agencies of government at the Federal level, then you've got States, and then you've got these quasi-state entities, these exchanges. All of these are players, plus private parties, companies and individuals. All of this interacting together across these multiple provisions, I think really is an extraordinarily daunting task from a managerial point of view. That's what I'm getting at, sir.
Okay. So thus, you have to have more folks collecting taxes, and the tax code is more engaged in people's daily lives and health care decisions.
Well, what I'm saying here is that the other piece, whether you can get this done or not, the other facet of my testimony is that I'm concerned that by doing this, by assigning these health care responsibilities to the service, which are contentious, they're certainly, as we know from this hearing, contentious politically, but they're going to be contentious for individuals because, as was indicated by the Chair, these are the intensely personal issue. That's what you used, the words you used, and I agree with that. You're adding into the interaction of the citizenry with the IRS another highly charged element of a conversation, if you will, and that can't help but impact how they feel about tax collection as well.
Well, Ms. Olson, to this point, with implementation and your preparations for implementation of Obamacare, how daunting and how difficult is this task going to be for the average American to be in compliance with this? You say that, with the mid-year they're going to have to update if they change jobs, if they receive more income rather than less, or less income rather than more. Well, for your planning purposes, how complex is this going to be, and how much of a challenge is this going to be?
Well, it is going to be a challenge for individuals and the IRS and for the exchanges, and Commissioner Everson is correct about all the moving parts. The taxpayers' ongoing responsibility to update is going to be not with the IRS but with the exchanges. Where the taxpayer is going to interact with the IRS is at the end of the year with the return filing, and that's where we do a reconciliation of what they got during the year and then what they actually were entitled to based on what really happened with their income and their family structure during the year. And there is a possibility of a gap between that, and that will come as a rude surprise to some taxpayers. That is why I've emphasized that we have to really educate taxpayers about their responsibility to talk to the exchanges. My concern is similar to Mr. Everson's in that taxpayers are going to look to the IRS, partly because we're talking about the IRS all the time about this, and call the IRS and want to give updates of information to the IRS, and they'll be confused. Where do they go, and will they get to the right place, and will the IRS be helpful in telling them, here is where you need to go? I have said IRS employees have to have a Rolodex of where to send these individuals so they can get to the right place.
Oh, Lord. With that, I yield back.
Thank you. The Chair now recognizes the gentleman from Arizona, Dr. Gosar.
Thank you, Madam Chair. Ms. Olson, you made an interesting finding. Oh, by the way, I'm a health care provider. I'm a dentist, okay? So I know something about this. You talked about changing behavior. Is that pretty easy, changing behavior?
No.
How would you feel about that, Mr. Everson?
I'm almost 58. It's tougher every year.
Yeah, I understand that. Ms. Olson, are you familiar with the Advanced Federal Child Tax Credit?
Yes.
And what were the instructions to the American people? Please do not call the IRS, right?
Yes, that was in 2001.
How many calls did you get?
In one day, we got about, it was our first million-call day, and they called asking, do we really not need to call you? That was
So, I mean, when you're talking about customer service associated with this is much more complex.
Yes.
Would you say exponentially?
Yes, it goes to my earlier point. It's not that we have new powers or new duties. It's the scope. It's the amount of work.
So how many customer service people are you planning on hiring?
Well, I'm not planning on hiring people until I know what my budget is. I think that's a question for the Commissioner. I have heard that we will be focusing on about 800 FTE that will be partly IT and majority working on the customer service side.
Mr. Everson, tell me, given the quantum leap that we're doing here for customer service, in your estimations, what kind of customer service detail would we need to handle this?
I haven't studied in such detail that I'd be able to give you a number. I mean, and the service is more than capable of having that conversation. But you're really talking, just as the advocate has said, as Nina said, you've got a whole new area of responsibilities. You've got potential for whole new conversations. And the Act, frankly, it extends well beyond that. Small businesses. We work at Alliant Group, where I am now. We work with small and mid-sized businesses. They're flummoxed by the statute and all the different obligations they have. So there are lots of different parties that are going to be impacted by these changing standards, including maybe your dentist shop. I don't know.
Oh, absolutely. You know, we've kind of kept the Federal Government away as best we can. But and that's my whole point is this is an ongoing dialogue that should be going on the whole year, not just at reconciliation, because it's compensatory backlogged. So it's customer service intensive, would you say? So 800 FTEs ain't going to work.
Well, that's the specking out, but I have not seen the details behind that.
Going back to changing behaviors, when you're sharing all this information, you know, and exponentially enlarging the pool of people accessing your personal information, boy, I tell you what, you better have customer service. And it's, if I'm not mistaken, you're not really known for customer service, right?
We need to improve our taxpayer service.
So let me ask you this. What's your average wait for a person for customer service?
Oh, I think this year it was about 12 minutes on the main phone line.
For an expedited form, right? Mm-hmm. How much longer when you have questions?
I don't know the answer to that. On some lines,
hours, days,
for hours.
Yeah, days, and just staying on the phone, just trying to get somebody that's qualified to answer. Mm-hmm. And this is much more, as we've heard the witnesses talk about, exponentially just growing in size. Mr. Everson, I'm really perplexed by the safety, and I know I couldn't find at least a sizable leak from the IRS in personal information.
Right. But it's got a very good record. It
does.
A real strong point of the service.
But the one problem that we got is we're going out beyond that, because we're going to be sharing this with information all over the place. And we're also subjugating individuals to insurance companies, are we not?
There's a tie-in into the insurance companies. I'm not sure how that will work on the exchange of what they'll have in terms of the taxpayer information. But clearly, you're exactly right. When you get to the exchanges or you get to the other states, you're going to have a whole new set of players that are dealing with not just the traditional information, but even more information. So
how do we guarantee that that's, and you alluded to it, so did my gentleman friend from South Carolina. Right. You know, this is the potential to share very personalized, like the gentle lady up here sharing personal information. It's just,
there are no guarantees in this area, sir, and it just is a very significant area of continuing focus by the service. And I would tell you, any business in America now that deals with this kind of information, it's something that everybody worries about. But this does increase risk. That's all I'm saying.
One last question. Do you think that health care is individualized and should be personalized? patient-friendly?
Personally,
your point of view.
I'm not going to answer a policy question on health care. That's
I'm
not got a dog in that fight today. How's that?
You do, because your health is yours today, and you own it, right?
Yeah.
How about you, Ms. Olson?
I'm not going to answer that question.
You don't own your health today?
I do own my health today. I just went to my dentist last week.
God love you, and you're smiling. How about you, Mr. Yost?
I believe that my health care is personal, and I believe that the Affordable Care Act protects it.
Mr. Cannon, how do you feel about that?
Health care is, of course, an intensely personal issue, and there's a difference of opinion among, obviously, supporters and opponents of this law, because, so like other opponents of this law, I think that it's going to make access to health care less secure, not more.
Thank you very
and
much.
cause more people to fall through the cracks.
Maybe I misunderstood your question, sir. If you're saying, do I think information about my health care is personal and shouldn't be shared, yes, I agree with that.
Thank you very much.
Thank you. The Chair now recognizes the gentleman from Idaho, Mr. Labrador.
Thank you, Madam Chair. Mr. Cannon, my state right now, Idaho, is going through a huge debate about whether we should accept the health insurance exchanges, whether we should do a federal exchange or do a state exchange. And interestingly, I made a recommendation to our governor and our legislature that they shouldn't at this time accept the health insurance exchange as a state exchange, that they should allow it to become federalized. So I want to have a little discussion with you about this. Are these true state exchanges that we're talking about when you're talking about state exchanges under Obamacare?
No. The statute requires that every state-created exchange, in order to be compliant with Obamacare, it has to get approval from the Secretary. And the statute gives the Secretary the authority to heap pretty much whatever sorts of regulations the Secretary wants onto these state-created exchanges. So it really is a myth, the idea that states would be able to retain some sovereignty, retain some control over their health insurance markets if they create their own exchanges, because whatever the Secretary would be able to impose on a state through an exchange that the Federal Government created, the Secretary could also impose on a state-created exchange through regulation.
Well, you and I probably have very similar philosophies about the 10th Amendment and states' rights. It seems odd that somebody from the Cato Institute and a conservative Republican from Idaho are asking a state to forego the state exchange and actually allow for the federal exchange. Can you explain why?
Well, it's a little bit ironic, but if what you want is a federally run health insurance exchange in your state, which is really just a government agency controlling the private health insurance market, if what you want is the Federal Government to control your state, then the best thing you can do is establish an exchange, because if a state, the Federal Government will control it, and if a state does not establish an exchange, there might not be an exchange at all, because, as we all know, there's no funding in the Act for the Federal Government to create these exchanges. And it's not likely that Congress is going to approve that funding anytime soon. So this is a real problem for the administration. They're having to take money away from other things that Congress appropriated money for. I'd like to see an investigation into that, frankly. But the choice is not between a state-controlled exchange and a federally controlled exchange. It's between a federally controlled exchange and maybe none.
Okay. If a state would have set up its own exchange independent of Obamacare, would the IRS penalties apply?
The IRS penalties against individuals who do not comply with the individual mandate would apply.
Correct.
But the penalties under the statute, the penalties against employers, the $2,000 per worker tax that the Patient Protection and Affordable Care Act imposes on employers in states that create their own exchanges would not apply in a state that does not create its own exchanges. So Utah, for example, could avoid that very large tax on employers by not creating an exchange. And what this IRS rule does is it not only it first deprives Utah of that choice and then imposes that tax illegally on those employers.
Okay. But if a state sets up its exchange under Obamacare, it is subject to the IRS penalties, right?
It is subjecting its employers to the employer mandate, which is a $2,000 per employee tax.
Okay. So when you're making the decision about whether you're going to set up a state exchange, you have to think about those taxation issues for your employers in your state.
As well as what employers in neighboring states the governments in neighboring states are doing. Because if you're in Utah and your neighbors all decide not to create a health insurance exchange, but you create one, you'll be imposing a tax on your employers that your neighbors are not, and they may want to leave your state for other states.
Okay. Isn't it true that under the actual text of the law that if a state does not set up its own Obamacare exchange and the Federal Government steps in and sets up its own exchange, that the IRS penalty does not apply?
The employer mandate, that is correct, because what triggers that $2,000 tax on employers is when one of that employer's workers receives a tax credit through an exchange. And again, under the statute, if there are no state-run no state-created exchanges, there can be no tax credits to trigger that penalty against employers.
And in the concept of federalism, the concept of having the state create something that it can manage, is it truly a state-managed exchange if you're doing it under the rules of Obamacare?
Absolutely not. And for the reasons I just mentioned, as well as the fact that there will be hundreds of billions of dollars flowing through these exchanges from the Federal Government. And so the Federal Government is going to be controlling all of that money. And the golden rule applies here.
So, and I just want to be clear. So when you say that, you mean that since they're controlling the money, they're going to be telling the state what rules apply for that state exchange and what compliance?
That's correct. For example, Utah's exchange would not qualify under
Obamacare, correct? Even though they did it before Obamacare, correct?
Correct.
So in essence, the state exchange is another federal agency.
For which the states will have to pay. Because if a state opts to create its own exchange, it's responsible for the operating costs of that exchange, which could run, the estimates have been $10 to $100 million per year.
All right. Thank you very much.
Thank you.
Thanks to the gentleman. I now recognize the gentleman from Pennsylvania, Mr. Kelly.
I thank the Chairwoman. And I thank all of you for being here today. This is critical. I had a conversation yesterday and then also today with Stephanie McCafferty, who I'm an automobile dealer, still own the business. My son runs it. We did build it by ourselves, by the way. And we've had this continuing conversation trying to determine exactly what this new Patient Protection Affordable Care Act actually does to us. And I got to tell you, even after sitting down with the CRS for an hour, everybody still scratches their head and says, you know what, we don't know. We just don't know. So, Mr. Olson, or Mr. Everson, let me ask you this. Is it true that the IRS will have to collect Obamacare's employer mandate penalty? Yes, sir. There will be an obligation upon the service, like in many other areas, to make that assessment based on the information that is provided. And that mandate penalty amounts to what, $2,000 or $3,000 penalty per worker?
I believe that's the case. I'm not an expert in the exact figures.
I haven't found anybody that's an expert in any of this, so you're not offending me by answering that way. It's difficult. It's a very difficult thing. And also, since the Obamacare mandate penalty is assessable in the same manner as other employment tax penalties, is it true that the IRS does not have to offer the employer an opportunity to review and contest the determination prior to assessing the penalty?
Well, I would say, sir, that's a question for the service to address. It's an interpretation of the law, and then they've got to write the appropriate regs. And I would expect that the service will be very careful in laying all this out and want to get, because of the problems that we've been talking about all morning, the nature of small businesses, the lack of sophistication and understanding of the tax code, they're going to want to get this right, whatever they do. Yeah. So they're going to have to work very hard, but they're going to have to work very hard to do it. And then that's one piece of it. And my other concern is then whether the folks in the businesses will understand it, actually.
Yeah, and you know what, in our business, we buy and sell cars, and we service cars and trucks, and that's what we do.
Yes.
Now, in addition to that, the greatest amount of time we spend now in the back office is not dealing with the services that we offer our customers. It's trying to be in compliance with the government that continues. I mean, I got to tell you, when I'm opening the mail, if it says it's from the Federal Government, the State Government, or local government, I say, oh, what are they going to take from me now? Or how are they going to regulate me that's going to make it harder for me to get through this business? And is there any appeals that exist that come into play, and it happens after the collection begins, right? So if IRS comes in, they sit down, they talk with me and say, by the way,
it starts now. It starts today.
The service has very clear procedures on appeal rights, and even before things happen, you can raise matters up with supervisors. But I do think that they're going to be, this is another area where there will be more confusion. Some of these, as the taxpayer advocate has indicated, the provisions are different in certain standards as to what actions on an enforcement side the service can take. I've written in my testimony, I'm concerned about that. Anytime you introduce variability into a huge operation, it's harder to run. So I think that these are all issues that are going to be tough to deal with.
Yeah, and really, I am on board with you. It is truly the uncertainty of what this law is asking us to do that creates this. I'm talking now about job creators. You've got to stay on the sidelines because you're not sure that your actions are going to cause a problem for you. And I've been through tax audits, and I got to tell you, the thing that strikes fear into the hearts of most Americans is that the IRS is coming in to do an audit. And you say, you know, my gosh, I know we did everything we thought we were supposed to do, but I guarantee you that small business owners who do not have, as you say, a level of sophistication, and as you would admit, I mean, who does have the level of sophistication? It's certainly, even this panel with its vast knowledge and its experience to say, I know something about it, but I don't know everything about it. And then we go to the job creators, the small business people, and say, hey, you know what, the ball's in your court right now. How do you stand up and do that? So let me ask you, Ms. Olson, how long does a business have to pay penalties assessed by the IRS under the employee mandate?
There is a 10-year collection statute. And I do want to say about the penalty, the small business penalty, that it applies to employers with over 50 employees. So there already is carved out by the law the very small. And I think Commissioner Everson's correct that we've got to really work on this with the regulation and the appeals procedures, and if there's an ability to get reasonable cause, abatement of penalties, the things that we normally do with penalties. Those are very important issues.
Yeah. Well, you know, and again, if I understood, you said the penalties are very small?
No, the penalties are, they've exempted the very small businesses from the penalties.
But under 50?
Under 50 employees.
Okay. Well, a lot of my friends have more than 50 people, so it applies to an awful lot. So if a business reports an IRS error, how long will it take the IRS to fully investigate? Any ideas at all?
The IRS has three years from the filing of a return in general to investigate.
Okay. All right. So I would just suggest, and I offer this only as a small business person who's lived in the private sector for his whole life, gosh, you're making it hard for us. You're making it so hard for us. I would ask each of you, who signs your paycheck?
Sir, I would tell you, you've made it hard for taxpayers, not the IRS. Let's get this right. You wrote this law. The Congress did.
No, you know what, Mr. Everson, I just got here. I've only been here for 19 months. No, I didn't write it. In fact, nobody even read it before they passed it. So let's make sure we're very clear in what happened, okay? And even the people that are sitting here in this panel today cannot tell us specifically what the penalties are going to be and how much it's going to cost small job creators like myself. So when we can tap dance around this and we can pretend that it didn't happen, I'm going to tell you right now, this government is crushing job creators and turning away and saying, you know what your problem with you folks? You just don't have the level of sophistication to understand this entire law. And as a matter of fact, neither do we. But we do have the ability to come in here and tax you. We have the ability to come in here and shut you down. We have the ability to hold you accountable for a law that not even we understand. So how do you like that, Mr. Car Dealer? How do you like that, Mr. Carpenter? How do you like that, Mr. Manufacturer? How do you like that, Mr. Miner and Steel Worker? Come on. Let's be honest with each other. This is absolutely astounding that we even have to have this conversation. You are paid by the same people that I am paid for right now, and that is the taxpayers of this great country. And we have made it so hard for those folks to live the way that the founders designed this place. And I'm going to tell you, I'm going to yield back my time because I'm way over time. But I will tell you, I will never stop fighting for the small job creators that are out there and the small business people who have nobody else to turn to. I've sat through it, and I mean that sincerely. There's nothing that strikes fear in the hearts of people that own businesses and the fact that the IRS is showing up. Boy, I'll tell you what, you try to circle the wagons and get all your information together. When it comes to the point that I have to worry more about not competition down the street, but I have to worry about my own government holding me back, there's something wrong.
I thank the gentleman for yielding back. I thank our panel for the generosity of all of your counsel. Mr. Everson, I appreciate your recognition, and to be honest, you're seeing both sides. I agree with you on a personal basis that Congress deserves the blame, noting that you're no longer on the Federal payroll. Ms. Olson, I'd like to thank you personally for the fact that your various reports and counsel of some of the areas of concern were areas that we took note of here. Professor, I thank you very much for putting out your position in a very accurate way. I appreciate your being here. Mr. Cannon, it's always a pleasure to have Cato represented here. I think you did a great job of expressing their concerns. Ultimately, much of what we said here today will ultimately be decided outside of Congress in all likelihood. This has been a great panel, and we stand in recess. And yes, Mr.
I just want to thank the Chair and the members for keeping me out of this exchange fight. I didn't get any of the questions. Thank you, sir.
Well, Mr. Everson, as you go back and talk to small businesses that you consult with, I'm sure they will have questions about that for you. So you're not going to be out of the fight and the other side of your life. Thank you again. We stand in recess till 10 minutes after the second vote.